What I will do is flag two sets of things for discussion. One is reality from the ground, and then I'll ask certain set of questions about the how the question of dignity is handled by the courts, and what are the assumptions that crop up when we observe what is happening in the criminal justice system. First thing is about what are the sides of dignity or indignity that people, especially citizens in conflict with law, experience. Uh, I always get this feeling that middle class doesn't know anything about it. At the same time, I also think that the kind of indignities that people in conflict with law experience is also very widely discussed in public fora. The first one is at the beginning, like even before somebody is formally arrested, in the name of search and seizure, how the family members of even the accused are handled is there is a lot of debate whether how far they can go. CRPC talks about it. How police use their high-handedness in dealing with them, and it's not just the accused but the entire family, friends. There are, I mean, as a human rights activist, I can say that in order to arrest the actual accused, there are hundreds of instances where family members are almost put in custody without FIR or anything. This is one site that is always, there's one way of subjecting the family members of the arrest, the accused, to all sorts of indignities is one method that police always resort to as a normal practice, unless the accused is from a middle class or from very powerful social circle. This is this is known to the in everyday practice also it is known. And even when an accused is arrested, now I have done a lot of work, especially on custodial deaths. I must have visited all the police stations in Hyderabad in the past 20 years. I can say that in any casual visitor to a police station, you will see the state of lockups. Like they might be dirty, tainted walls, broken floors, dark cells, and suffocating police custodies. They are all seen as a norm. They are not an exception at all. Even judicial officers, even senior officers also visit them, but they never think that this is not the place of living that an accused deserve. Okay, uh, that has become a norm, and there is a lot of debate about when handcuffs can be used against any person in custody. DK Basu talks about it, and they say that it also authorizes you can use the handcuffs as a method of security, but usually it is a method of humiliating. Yeah, I mean, anybody who walks into the corridors of court also, they will see at least South India is far better. If you go to North India, some 20 people are tied to a same rope as if they are an animal. In front of Nagpur Central Jail, I've seen a lot of times. In front of even Bhagalpur Jail also, I've seen it. So people are tied with a rope, single rope, and they are paraded. So the media watches it, and judiciary also knows about it because to the same prison, judicial officers also walk in, walk out, but they seem to never object it. Even in the corridors of the courts, when they are produced, just before they are produced into the court, the handcuffs are removed and then produced. Otherwise, it's a very normal, common view for every lawyer, but nobody seems to object to this kind of practice by the state. Uh, I have done some 25 interviews about women prisoners. What I found out, especially at the time of entry, more than men, women prisoners are far more seriously humiliated. They are absolutely made naked, if not in front of other prisoners, but as individuals also in the name of no, in the name of no checking. Uh, Similarly, even men, if you, I mean, all the students that who visited with me to the prison, Chanchalgoda or Central Prison in Hyderabad, Charlapalli also, they are witness to the scene that 20, 30 men prisoners, most of them are made to squat uh, in underwear for 1 hour, 2 hours before they complete the formality of no, writing, registering their names, father name, and moles and everything. Why do they do? And also in prison conditions, recent judgment on Sukanya Santa, everybody knows how in the prison, the prison labor is allocated on the basis of caste. That's not one thing. There are so many other forms of indignities. In the prison barracks, in the same barrack, there will be toilets without doors. At least there is some improvement in the recent past. Off doors and open air bathing. These are all no, methods of dealing with no, prisoners. What exactly these kind of experiences are meant to, or what they are expected to, what effect they do on the prisoner? That is the central question. Fundamentally, when they are handled like this, especially inside the prison, that breaks them down completely. Their sense of confidence. They understand the power of the police and the prison, and a kind of it establishes highly asymmetrical relationship between the minions of criminal justice system and the accused. That is the signal. I mean, 25 years back, Maya Daruwala asked me to translate an essay in which how to observe power relations between prison officers and the prisoners. The body language, how they greet each other, how they never actually uh, use their hands, and quietly they walk. They never look into the eyes of the prison officer. There are hundreds of ways that you can actually see. So in the prison clinic also, when I take the students to the prison, I tell them, please see the body language of the prisoner. You will understand what exactly is happening. Whether prisoners are capable of asserting their right to self-dignity, their rights, can they ask why somebody is treated the way they are being treated? There are separate confinements and they are not allowed to speak to anybody. These are the different methods now that are used. Especially in Hyderabad, every day around 200 to 300 prisoners visit courts. And for Hyderabad, despite being such a big city, these prisons are supposed to be local courts. Therefore, they are never allowed the lunch allowance. Despite district judges writing to the government saying that the prisoners starve the whole day in the prison. The prisoners are made to wait in the police van the whole day, even without going for a natural call. Okay. So government has not changed the rule that for Hyderabad the prisons are local, therefore they cannot be given their lunch allowance. Not just it's just a 60 rupees. So prisoners starve and then go back to prison by evening 5 o'clock or 6 o'clock. By then their lunch is over and then they're supposed to eat only next day morning. These are many methods, and also my lawyers can narrate whole set of stories about prisoners come to the court and they wait the uncertainty whether the court is going to hear their case that day or not. Same is the case. What is the nature of relation between a prisoner and also a lawyer. What is the relation between nature of relationship between public prosecutor and the prisoner? Yes, sir, there is a palpable entire subordination. They are almost not citizens at all. They are just subjects. The, the moment we talk about the Reformation and also the moral character of the people in conflict with law, the question of agency completely disappears, which is central for the idea of dignity. The concept of honor completely disappears. So without agency, without honor, there is no question of no respecting their dignity, which is foundational for the whole question of rights. So in the entire prison manual, you don't see a single word called right. It is only privilege. Why they are called privileges? That can be taken away by any time. So there are the whole unwritten code of conduct that really governs the relationship between the minions of the state and the people in conflict with law. And I mean, I can use the language of Foucault. It's the technology of power, pattern. It's a messy world. Saying it's a very messy world is much easier. But pattern can also be discernible. There's nothing. It's not very difficult. There is a systematic pattern where the people in conflict with law never allowed to think that they have an agency. And it is left to the legal representative, their lawyer, to represent all their concerns. Prisoner himself is never allowed to speak up in the court or in the prison. So when there is no question of agency at all, there is no place for the whole idea of concept. So we can ask some fundamental questions. I mean, whoever has read a little bit of Constant Assembly debates know about why the dignity of the individual, securing dignity of the individual precedes before the unity and integrity of the nation. Famous Pattabhiramaya asked this question that it should be reversed. That unity and integrity of the nation should come first, and then the dignity of the individual should come later. But Ambedkar firmly stands that without ensuring dignity of the individual, you are not going to build any integrity. I can understand it is about individual rights when it is in conflict with public interest or collective interest. If we apply that framework, even if we accept that all the people who are in conflict with law are the people accused of violating dignity of the other individuals, and there is a conflict between the dignity of the victims of crime, should we not also seriously take interest in the dignity of the victims of the system? If preamble says secure dignity of all the individuals for all citizens, what was the immediate context? The immediate context was the arbitrary nature of the colonial state, against which we have had a 90 years of struggle in the name of nationalism. So the arbitrary and cruel, I mean, my friend says that entire colonialism was based on cruelty and loyalty. So colonialism is one of the sources of indignity. But in 372, we have adopted all the colonial laws as it is. 13 is only an exception. Now, whether there is a transformation of nature of the power from being arbitrary to being democratic, especially in the practice of criminal justice system, is one central question we have to ask. We can talk about any number of concepts which are being used by the higher judiciary. But how to convert all these uh, beautiful concepts into practice at the lower level is one of the fundamental challenges before us. And people, citizens who are in conflict with law, as a class of people, are they excluded from the constitutional vision of ensuring dignity for all the citizens? It almost appears to us that those who are in conflict with the law don't deserve to claim the constitutional vision of dignity. And one question that finally, after listening in the last panel, I had one important doubt. That is, if we understand that human dignity is inherent and also human worth is also inherent, can it also be simultaneously dependent on others? Of course, I agree. I think that if we accept it, that human dignity is inherent and human worth is also inherent, and when you claim that as a right, you also have an obligation to respect the human dignity of other person. But even if we accept all those people who are in conflict with the law needed to be broadly said to be controlled on whatever method, still how to ensure human dignity of the people, their human dignity by the criminal justice system, unless there is already a consensus subjecting people in conflict with law, including convicts, subjecting them series of indignities and humiliations is part of punishment. I don't know whether there is a consensus subjecting people to series of indignities and humiliations is central ingredient of punishment. I don't think we have ever had that kind of consensus. But even without convictions, in the name of pre-trial detentions, a series of humiliations and indignities are hurled at 18 lakh people per year. It's not 1% or 2%. We are able to tolerate it because there seems to be a criminal law common sense which refers to certain kinds of beliefs and certain kinds of practices which are normal, and this is what they deserve. I think this is the context in which I want further discussion on the question of dignity. Thank you.